courts upheld the norm that the government really stepped into your shoes.
Absolutely.
And filed a claim. Once they step away from them, who stops the government from doing something, or from you from saying, look, the
structure of my arguments will attempt, the structure of my arguments, my lords, will attempt to lay a foundation based on a gross miscarriage of justice, and then build on it squarely within the technical aspects of the law as it stands today. But my lords, perhaps first things first, who are we? I am not an NGO. I am not third parties looking to, or busybodies looking to do good at best, or at worst, profit from the survivors' misery. I am the survivors themselves. I have 5 organizations of survivors who have organized together in various respects. The first organization is, in fact, a trade union of a factory that was set up by the government in order to provide some employment and some succor to the survivors. My lords, if I will have a very brief time, if I could just...
On the paper. Referred to in the note.
My lords,
papers filed by them, which are
my lords, I will come to all of it. I'm grateful for the protection. So, my lords, this factory was set up to provide succor and employment, whatever employment they could do, because there wasn't so much that they could have given the health damage. And the first organization, for example, is a trade union of those survivors. There are other organizations. One is widows, disabled survivors, others who are claiming welfare benefits as survivors, banding together and supporting each other. All of these, my lords, was laid out in IA 729, and IA 729 was first allowed without any conditions. And then, and at that time, I was 11 years younger, and Justice Lalit was then a senior advocate, was leading us in the criminal curative. And pursuant to those submissions, the court examined the issue and said, very well, and this is the order, my lords, that, can you pass it over?
Yes.
My lords, in fact, in a lighter vein, I was briefing Justice Lalit in an entirely different matter, in a matter in which our client was, allegedly committed all sorts of terrible crimes. And he said, I was reading about that matter and I would like to help you. And that's how he came in. So, my lords, at the bottom of page 3, no, page 2, is the revised order.
Yeah.
Interlocutory applications number 7 to 9 are allowed, subject to service. And that was the part that was not read out on Monday. Issue notice on the maintainability of the interlocutory applications and merits of the matter. Previous to that, my lords, was the order.
And I see your problem is you are constrained by certain part of legal history which has happened, and it's difficult to go beyond it. So one of the issues is that at the relevant time, the courts upheld the norm that the government really stepped into your shoes.
Absolutely.
And filed a claim. Once they step into the shoes and that provision is upheld, there cannot be a separate channel of your representation that, look, as if they have not done the job which they're supposed to do. We are faced with the scenario of a much later scenario of a curative petition. It's not an original petition which we've been telling the learned attorney also. So now, having settled it for A value or B value, whatever it is, nothing prevents them from doing more for you. We are not saying they should not do more.
That I'm very grateful for, my lords, that we will be not left without anything, because I'll demonstrate the hardship that's currently.
They can do more for you. They apparently have not done something which they were supposed to do for you in view of
Many things. The governments over there are many.
So, but in this matter, we are only our issue is only this: can we, on part of any of your interests,
Yes, Manoj.
pass on anything on them? That's the government stand. That we recover
Absolutely.
from them. Who stops the government from doing something, or from you from saying, look, the government should do this more?
Yes.
That's the difficulty. How do you say a settlement subsists,
Yes, Manoj.
but it's kind of like top up the settlement? So that's the whole issue. Can we top up the settlement which is there?
My lords, in fact, the survivors are relying on now on the documents that have been placed by the learned attorney. And what we are merely,
We can't, see, we said in the beginning, we
Yes,
will
sir.
not look into documents, whether the government or yours or anybody, post what had happened at that stage of time, because it's curative. So the difficulty arises, we can't forget this side, that what jurisdiction we are exercising.
absolutely.
And we are
Of course.
by the jurisdiction.
Of course, my lords, the curative jurisdiction is exceedingly limited. And perhaps when we filed originally our application for directions, we asked for the world and we sought too much. So now what we have done today is that we have limited our plea to what has been falling from my lords and to what we see as falling squarely within the technical considerations of the curative jurisdiction, as my lords have exercised in the only 4 judgments that have allowed curative. And we will demonstrate why the gross miscarriage of justice, which is a very, very high standard, is perhaps met here. My lords, if I may go to the structure of our arguments so that I myself don't get derailed, by going on too much about a particular point given. Now, my lords, the second point in the structure, this is on the top page, is that it is now settled law under the law of absolute and strict liability that private profit-making enterprises that use hazardous material in a profit-making activity will have absolute and strict liability for any damage that stems therefrom, and including, the example is given, if a gas escapes. This principle, and the judgments say this, also exist in significant part because these enterprises have exclusive knowledge of the makeup of that hazardous material, the toxicological impact of any damage that is caused by that hazardous material, the mitigation and the ameliorative possibilities that can then lead to any medical care, categorization, etc. Number 3, there is no other way to say it. We tried in conference to find other more gentle ways to put it. But my lords, a fraud has been played on this honorable court, on the Union of India, and on the victim. In the first part, it is because there was a suppression of material facts that go to the root of the settlement. The first study, internal safety study with regard to methyl isocyanate, was commissioned and obtained in 1974.
Is the fraud period as a ground in curative petition?
My lords, in curative petition, there are three,
No, we are asking a very fundamental
ma'am.
question. You are intervener.
yes, ma'am.
Is fraud pleaded as a ground in a curative petition?
My lords, fraud is pleaded as a ground in our impleadment application that my lords had allowed. All of this is there. We are only limiting it. We have not extended it. We are only limiting it, my lords.
The problem is this, you see, in some way, you are doing piggyback on the curative petition file. Otherwise, you would not be, intervention would not be. So, when you seek to piggyback, then you can't go beyond the four corners of what the curative means. You are in a way supplementing that and
The
saying that,
attorneys.
look, this is the curative petition, we are the affected parties. Being an affected party, therefore, look to our point of view also. But the point of view will have to be constrained, as my brother put it, the four corners of a curative.
Yes, ma'am.
So, and the whole problem is that if, now, for example, your point 3.4 is fraud resulted in wrong categorization of injuries.
Yes, ma'am.
This is something to be done by the concerned authorities there. Nothing to do with that, in a sense. Fraud resulting in undercompensation. Again, all this would require, as we said earlier to the attorney also, saying you reopen the whole case, start the trial again. This is the consequence, unfortunately. And what kind of evidence one would lead? You are saying there are some evidence in terms of documents
Yes.
nationally available on their conduct. Okay. But to what extent that conduct affected the people involved is an evidence. It'll be an unmanageable affair, much as you may have a point.
My lords, what we have attempted to do is to propose the cleanest solution that we could imagine in the circumstances. And my lords, if I may just be permitted to go through the structure,
Yes.
and we'll address all the questions when we come to the.
Yeah.
So, my lords, suppression of material facts, this internal safety study and the Carnegie Mellon study that they had, two studies that they had commissioned, says specifically that there is major and residual injury caused even when a small amount of methyl isocyanate is inhaled. Now, my lords, I will demonstrate all of this, that this is, of course, the inverse of minor injury. And in a top secret meeting, which we obtained by RTI with the government, the top secret meeting with the government that Union Carbide had sought back in 1985, 2 months after the Bhopal gas disaster, they proposed categories of minor injury, of temporary injury connected to work. And these categories were made their way as is almost in the scheme, because of course the union would rely on the companies. Now, my lords, coming to the next point here, that per the experts and the ICMR reports, the injuries resulting from MIC exposures are permanent. Now, my lords, the ICMR, which is the government, apex government body for medical research, realized the permanent nature of these injuries and indeed the progressive nature of the minor injuries, of even the mild exposure. Because now those cohorts are dying at a much greater rate than the normal population. In 2004 and subsequently, in 2009, which is when their reports came out, because they did not have the benefit of the many toxicological studies that the company that had exclusive knowledge had done, and to this date, they have not disclosed those studies. What we obtained through the very rigorous United States discovery process where no documents cannot be suppressed. The second we obtained through the Environmental Protection Agency, even though Union Carbide had said to them that please do not, this is confidential, do not disclose this document because it is our property. We have that document. My lords, the next point is that 25,000 rupees is what 93% of the victims got in the first round. And then Justice Muralidhar was leading for these 5 groups that I'm now representing before me. In 2004, he came to my lords, and my lords had given another 25,000 rupees in order to disburse the rupee devaluation amount as well as the interest that had accumulated. So the vast majority of people, 93%, and this was read out by Union Carbide also, they have relied on this figure, have got 50,000 rupees over a lifetime of cancer, of liver damage, of chromosomal defect, which comes to about 3 rupees per day. Now, my lords, coming to point B. The settlement consisted of 2 portions, a civil and a criminal. The review judgment is a final determination of what justice will mean for me, for the victims of this gas disaster. That review judgment was concerned with the settlement, which I will be addressing in the first part, and it was also concerned with the criminal. Counsel for Union Carbide then had invited the jurisdiction of this court, citing the Sancheta judgment under Article 142, saying that the criminal cases against Union Carbide can and must be quashed or withdrawn as the union had then proposed. And this court said no. This case must be investigated, that the criminal cases must go forward, and at no point did Union Carbide say that you do not have jurisdiction over us. This argument is without prejudice to jurisdiction.